Okay, so today we take up a new jurist. His name is HLA Hart, or Herbert Leonel Adolphus Hart. He's a very important jurist within the area of legal positivism. He is known for his very important book by the name The Concept of Law. Okay, sorry. So he's another legal positivist. So why do we need another legal positivist when we already have discussed two of them? Well, because his approach to uh, defining legal positivism is much different from the previous two that we have studied, that is Bentham and Austin. So it's a departure from their command approach to defining law. So Hart's conceptualizing of the idea of legal positivism started with a criticism towards the existing understanding of legal positivism, as was conceptualized by essentially John Austin. So he is a very severe critic of the command theory of law. Essentially, the reason being this, that in command theory of law, you see there is unidirectional flow of power and authority, which is not what actually happens in legal system. In legal system, it's not merely unidirectional flow of authority, like it's not unilateral direction of command, which is then followed by sanction. But it's not merely the threat or fear of sanction that gives rise to obligation on the part of the citizens, okay, towards whom the laws are directed. But there is also this aspect of acceptance of the law on the part of the citizens, okay, the ones to whom the law is directed, which is lacking in the works of the previous legal positivists, like that of John Austin and Jeremy Bentham. So yes, so he starts with, as usual, as you would expect, he starts with a criticism of the idea of sovereign, okay, the legally unlimited, okay, idea of sovereign, okay. So how to say that? Well, you cannot show us any sovereign which is not legally limited. Okay? In practice, you cannot show us case of sovereign which is not legally limited. So for that matter, even the British sovereign, which is probably the exemplar of the idea of sovereign that Austin was talking about, even there, the so-called sovereign is legally limited. We already have discussed that earlier while criticizing John Austin. So here he says that, so for example, the crown, so you might think that the queen there, okay, who is probably the ruler, okay, who's probably the sovereign, if you understand it that way. Even who succeeds to the throne is determined by a certain law. So you cannot pinpoint one, determinant, a person or body of person, as Austin would say, and then say that, okay, here's where the sovereignty lies, and here's where from you have unidirectional command directed at political subordinates. That's not what actually happens in legal system. Is the criticism which was directed towards Austin's theory by HLA Hart. Another aspect, as I told you, is that law is not merely unidirectional flow of authority, but there is also this acceptance of the law by the people upon whom it is directed. So essentially, the idea is that even when people probably do not like the way the law affects them, even then people generally have this idea that if there is a law, they ought to abide by the law as it exists. Obviously, it's not the case that everyone feels that way, but then there is this general idea that, okay, there is a law, okay, and if there is a law, then we ought to exist, and we ought to abide by the law. So the essential distinction that he makes here is that, if you look at the Austinian sovereign, as Austin was talking about, it seems to be a case of someone pointing a gun at your hand and asking you to hand over the money. Okay, now that seems to be the kind of lawgiver that Austin is talking about. However, there is something lacking there. Okay, why is it that we say that laws which are made in the state, okay, are not the same kind as a robber who's pointing a gun at your head and asking for money? So you say that in the case of robber, the robber is breaking the law, but you do not say the same thing when it comes to laws of the state. Okay, so what is it that makes the difference? Okay, that's something that has not been addressed by John Austin, which will be, as you will see in the course of time, has been addressed by HLA Hart. So yes, he, because of all these criticisms, okay, because of these shortcomings that he identified with the existing hard legal positivism in the theory of Austin and Bentham, that he conceptualizes a new kind of positivism that he calls a version of soft positivism. Okay, now why is it soft? It's essentially this. If you remember, Austin would say that law is possible only when there is a political society and it has a sovereign. Okay, so if there is no sovereign, there is no law. So by that definition, it seems that most of the places around, in the rest of the world, especially in the East, there will be no law, because we do not have the same kind of, many of these places do not have the same kind of authority or sovereign that Austin was conceptualizing. So would we say that there are no laws in all these places? So as opposed to what Austin would say that there are no laws. Our philosopher here, HLA Hart, says that law may exist in a society as a matter of practice and observance, even if it is not officially declared to be law. So you do not need such sovereign to declare the law. Even in the absence of such a sovereign, laws could nonetheless exist as a matter of practice and observance. So there could be certain rules which do not emanate from any specific sovereign authority, but they are nonetheless there among the people, and they guide their behavior in accordance to the rules that exist. Okay, so would we say that they are not laws? Okay, so Austin would say they are not. HLA Hart say that. Why would we say so? Okay, they can also as much be called as law. And secondly, he says that legal system may permit a court to apply moral standards in resolving a case before it. Okay, so it's essentially this, that earlier the idea of separation of law and morality was taken a little too seriously. Okay, that as if there is no connection of law and morality. But as of now, the new idea of separation, essentially, it's probably better to say that call it as separability thesis rather than separation thesis. Simply because of this, that now it says that there is no necessary connection between law and morality. Okay, that means that quite often it is possible that judges, while deciding a matter, okay, they apply certain moral standards, certain moral considerations, certain policies, social policies. It's very much possible for them to do so, but that does not make it a law, because they decide the matter in the light of those moral standards or social policies, but because judges have applied that in those specific cases. Now, we will later on see that there are certain philosophers, especially Ronald Dworkin, who objects to what HLA Hart says here, that we will deal with later on. So yes, this is essentially the separability thesis. Okay. So before we go ahead, let's understand a little more what this separability thesis, okay, or separation of law from morality essentially means. Okay, so I told you guys earlier that it essentially means that there is no necessary connection between law and morality. When I say so, what do I mean by that? It's essentially this, that whether the law is valid or not valid, so legal validity, okay, does not depend on whether the law is moral or immoral, whether the law is just or unjust. Okay, so the question of whether a law is just or unjust is separate from the question of whether the law is valid or not valid. Now, why is it the case according to the legal positivist? Why do they insist on this idea? Well, just like the previous positivists that we have discussed, for our philosopher HLA Hart here, the reason for him arriving at that conclusion, okay, is utilitarian, okay, in nature. So what is that? That it's better to not confuse what is law with what law ought to be. Okay, these two things should be kept separate. Okay, so law is a social fact. Okay, so if it is a social fact, okay, we should be able to describe what the law is without getting into the questions of morality. So what law is should be kept separate from what law ought to be. Okay, so here we are going to use the word ought later on in a different sense, as you will see HLA Hart using in his entire idea. But then that ought, the sense in which the word ought is used by HLA Hart, okay, in the legal sense is much different from the moral sense in which we use, for example, the word in which we use the word ought. So what does that mean? So it's essentially this, that when we talk about morality, okay, there are certain very specific dictates there could be. So for example, you shall not kill, you shall not murder, you shall not steal, you should not covet, whatever. Okay, there could be many different things that there could be, for example, moral rules that say that homosexuality is not okay. It is not okay for someone to undergo abortion. So all those things could be there. Okay, so those are specific questions of morality. Okay, so HLA Hart would say that those questions of morality should not be considered as defining criteria for the concept of law. Okay, so he says that, let's not mix up what law is with what law ought to be. So essentially the idea is this, that he would say that why is it that he insists on this separability? It's essentially because of this, that let's not confuse what the law is based on our subjective moral preferences. So it is very much possible that there are many of us within the society. It's possible that we come to different moral conclusions about the same subject matter. So there might be among us who are not okay with abortion. There might be among us those who are okay with abortion. There might be among us those who are not okay with same-sex, marriage, pornography, etc. And there might be those who might be okay with it. Okay, so there are possibilities of many different, moral positions. Okay, if we were all to judge law in terms of its moral qualities, then it's going to be very difficult for us to conquer on the idea of what is law. Okay, because there will be always someone who would say that, okay, this is not law because this is not in accordance with the principles of morality. So if we do that, we create kind of confusion about what the law is. Okay, so to avoid that, to get clarity about what the law is, he talks about separation of law and morality. Okay, so what he's essentially saying is that the question of legal validity does not depend on whether the law is just or reasonable, or they are in accordance with human rights, etc., etc. Okay, those are external questions. Okay, so what would then determine legal validity? Okay, so you would say that there might be certain basic conventional criteria, okay, in a legal system, and from that conventional criteria you will trace the legal validity. So in his work you will see that he talks about something called rule of recognition that we will study in the course of time. So rule of recognition essentially determines what the law is, okay, what the rules are, okay, in a legal system. So If a rule is recognized by the rule of recognition, okay, then you can say that yes, the law is valid. So in such case, once it has been, the rule has been recognized by the rule of recognition, then we do not go into asking questions of whether the rule that we are referring to is morally just or unjust. So it's possible that no one thinks that it's morally just, okay? That's a different question altogether. But then, if it is recognized by the rule of recognition, then you have to say that, okay, the rule exists and it's a legally valid rule, okay? So yes, those conventional criterions will determine whether the rule is there or not, okay? So that's there, okay? Another important distinction that he makes, okay? So essentially this, that positivists claim that propositions of law in which we state the existence of legal rights and duties are not moral judgments, okay? So you hear about rights and duties, okay? Legal rights and legal duties, okay? So when I say that I have a right to something, okay, right, that I'm paid certain amount of money, that I am be done something with regard to certain things, okay, that it could be anything that, okay. So in those cases, those legal rights that we are talking about, that I be paid certain money, or I be given education, or I be given healthcare, whatever it is, okay, the legal rights that you are talking about, okay, are they rights because morality requires so? The questions of moral judgments require so, or are they rights because the law says so? Okay, so a moralist would say that a rights, the ought in a right, that something ought to be done with regard to you, okay, in rights exist only because those are those are cases of, those are certain moral demands that you are making, okay. But as opposed to them, the legal positivists would say that such claims, okay, that claims of legal right that do not depend on moral questions, okay. So we keep this so it is possible essentially for us to talk in terms of rights and duties, okay, separate from the ideas of rights and duties as we talk about in the moral sense of the term, okay. So you could have legal rights, legal duties, and then there could be moral rights and moral duties, okay. That's essentially what they are talking about. Yes, so you do not have a legal right because there is a morally valid, argument in its favor, in favor of the right, but simply because of the fact that under the law you have a right, okay. So that's the distinction that they make, okay. Now at this stage, I would like to add something else, okay, that it's very much possible for us to misunderstand, what the legal positivists are saying when they say that law and morality at the conceptual level are to be kept separate, okay. So what is that? Are legal positivists saying that morality does not exist? No, they're not saying that, okay. They're not saying that morality does not exist, okay. In fact, if you remember, even when Bentham was criticizing natural rights, okay, that seemed to be pretty arbitrary, but he gave you an alternative, okay. The utilitarianism is sensorial jurisprudence, and purpose of that was to make the best possible policies, okay. So utilitarianism also gives you the tool to make morally right laws, okay, or policies, okay. So, and then when they talk about separating law from morality, they are, when they do so, okay, the justification for separation of law and morality probably as I believe, okay, also is based on some questions of morality, okay. That mixing law and morality every now and then would lead to confusions, and for the sake of clarity we need to keep these two separate, okay. So from that itself you can know pretty clearly that our positivists do not say that morality does not exist. Morality might very much exist, okay. So, but once the law has been enacted, that law's validity will not depend on questions of morality. You might think that it's not morally okay, but you cannot say that the law does not exist or the law is not valid. So they're saying that law could be morally wrong. So when they say so, they're saying that yes, questions of morality are very much possible, okay? All they are saying is that we do not determine the validity of law in terms of morality. So it's not necessary that legal positivists are morally moral skeptics. Similarly, they do not say that content of the law, the laws which are enacted, for example, as in the way that the positivists are talking about, they're not saying that such laws do not have moral content. Quite often laws do have moral content. How efficacious a law is in a legal system would surely depend to a great extent on how these laws reflect the morality of the society. But then the morality as accepted by the society will not determine the validity, as I said earlier. But quite often you will see that laws of a legal system do reflect the morality of a particular society. So you will see that in the Indian Penal Code, or for that matter any other law, you will see that and the laws prescribe what is also morally considered as wrong. So laws could have moral content. So positivists are not saying that law and morality, when they are separated, and that there is no moral content in law. That's not what they're saying. They're just saying that conceptually the idea of law does not require any specific moral content. And similarly, they're not saying that judges, when they decide matter, sometimes when they decide the matter, quite often they decide the matter in terms of the laws as they exist. Facts come before them. They have certain laws. They apply those laws in those specific facts. And they arrive at a particular decision. So questions of morality does not exist. But it's not that easy, as you will see in the course of time. So there might quite often come situation where the existing legal provisions are not enough. Maybe there is a gap in the law. In such situation, how would the judges decide? In such situations, judges quite often use their moral judgments or their understanding of social policies. They decide a particular case, as has been said by HLA Hart, which is objected to by other philosophers like Ronald Dworkin. So in such situation, it is said that judges do decide the matter. So judges do decide the matters in the light of their own understanding of morality, their own moral judgments, as well as social policies. So again, one might say that where is the separation of law and morality then, if judges are in fact deciding matters in terms of certain certain moral standards? Well, that is also not denied by positivists. So when they say that law and morality are to be kept separate, all they are saying is that conceptually they are separate. So in this situation, what the judges decide is not legally valid because it is in terms of in accordance with certain moral propositions or certain social policies, but because it has been decided that way by the judges. So that's what determines the legal validity in such situations. So they are not saying that judges do not take moral questions into consideration in deciding a matter. All they are saying, again, I would reiterate, is that conceptually you do not need the concept of morality here. So yes, hope you guys are with me so far. So, and then positivists do not necessarily deny that there may be moral obligation to obey the law. So quite often this is a question that arises. Positivists are all that the positivists are saying. The limited assertion that the positivists have, is this, that the legal validity, the question of legal validity and question of moral validity are separate. So whether the law exists or not, whether the law is valid or not, is one question. Whether the law ought to be followed or not is a separate question. So whether the law ought to be followed or not is a moral question. It could be a moral question. So you might find the law to be so egregious, outrageous, which we have seen already in case of Nazi Germany. it might raise a moral obligation on your part, as well as, for example, the judge who's sitting in a court deciding a matter and then finds the law to be abhorrent. So it could create a moral obligation in favor of in the judge, as well as, ordinary such citizens like you and I, to not follow the law. Okay, so they are not denying that moral obligation could say that you do not follow the law. They would just say that it just does not help us to say that a law does not exist, because it does not go in accordance with the moral judgments that we have. So this is essentially what their claim is. So positivists do not necessarily deny that there may be moral obligation to obey the law. Okay, so yes, why should I obey the law? You may have moral obligation to obey the law. So if you remember, Thomas Aquinas said that you might come across a law that you might think is unjust, but not following the law could have certain other moral consequences. To avoid that greater moral consequence, you may have to follow the law, because morality says so, more requirements of morality say so. So positivists do not deny that either. Okay, and positivists do not deny that morality might require you to not obey the law either. Okay, so that's in either of this case, they're not saying that morality does play a part in whether you should obey the law or you should not. Okay, that's not the case either. The limited claim that they have is this, that legal validity, or whether something is a law or not, okay, question of legal validity is a separate question from that of morality. So yes, at the end of the this discussion, we can surmise that this claims that the legal positivists make is about the concept of the law. Okay, it's not about whether this law or that law has moral content or not. Okay, so when they conceptualize law, in conceptualizing law, they do not see any necessary connection between law and morality, or you would say that they think that it is better to keep the questions of morality separate from the question of concept of law, okay, for the sake of clarity, which they conclude, which they think, is the right thing to do based on their utilitarian understanding of separability of law and morality. So I hope this distinction between separability, this idea of separability of law and morality is clear to you all. So yes, if this is clear, then let's proceed to what HLA Hart had to say about law. Okay, so as you know, so far we discussed how HLA Hart is different from Austin, how his approach is different from Austin's. We looked at his idea of separability of law from morality. So let's look at how Austin's positivism is different from that of so how HLA Hart's positivism is different from that of Austin or Bentham. So Bentham and Austin's positivism is also known as fact positivism, whereas HLA Hart's positivism is known as normative positivism. Okay, now what is the difference between these two? So just a second. So yes, this Oxford Dictionary defines normative, the meaning of normative, as establishing, relating to, or deriving from a standard or norm, especially of behavior, So, and then for Cambridge, dictionary, it says, just a second, relating to rules or making people obey rules, especially rules of behavior. So this is how normative has been defined. Now how we ought to behave, how we ought to obey rules, the content of that, where does it come from? Does it come from questions of morality, or does it come from somewhere else? Okay, so as you know, HLA Hart would not say that it comes from morality. If he says so, then he is essentially going against the idea of separability of law and morality, because conceptually you do not need morality. But then the idea of normativity, the idea of standards of behavior or rules of behavior, nonetheless exists within positivism, even when you do not derive it from any specific idea of morality. Okay, and where does that come from? It essentially comes from the rules that exist in a legal system. Okay, those rules, those laws, okay, that exist in a legal system could have normativity. Okay, even when you do not subscribe to any particular, okay, idea of morality. Okay, and how is that possible? Okay, what I ought to do, okay, what I ought to do seems to depend on certain moral judgments, certain moral propositions. In the absence of that, how can I talk about what I ought to do? Now, this is a very difficult job, that HLA Hart takes up and succeeds to a great extent in, establishing. So he is saying that law possesses some kind of normativity. So when there is a law, there is an ought expectation on your part to mold your behavior in accordance with the requirements of the law. Okay, now this is something that you do not see in the works of John Austin. Okay, so that's the difference. Okay, so we call HLA Hart's positivism as normative positivism, whereas John Austin's fact positivism. Now, what is the distinction? So here, okay, let's take an example and then explain. Okay, before we take the explanation, let's look at the definition given by John Austin. It says that law is the command of the sovereign. So command creates duty. Non-fulfillment of that duty will be meted with or followed by sanctions. Okay, now it is the threat of sanction. Okay, sanction is very integral to the command. Okay, it is the threat of sanction that creates the obligation in you. Okay, so whether the law exists in a particular case, in a particular situation or not, will depend on, for example, how likely is it that the courts will be able to enforce the law as against you? How likely is it that someone, a bad person, is able to escape the grip of the law? Okay, so it's purely descriptive in nature. Whether legal obligation exists or not, how likely is it that I'll be punished? Okay, if I were the person thinking of breaking the law, you're think okay, whether the legal obligation exists here or not. Well, how likely is it that I will escape punishment? If it is possible that I escape the law, okay, without being punished, okay, then there is no legal obligation. Okay, and that's the impression that Austin's definition gives us. Okay, so if I'm able to steal your goods, okay, without getting caught, okay, or then it seems that I do not have any obligation to obey the law. That's the impression that Austin's definition gives to us. But HLA Hart would not be content with that. He would say that, okay, there's something problematic about this entire situation. So quite often it is the case that people do commit crimes, they do break the law, and they also escape punishment. As you see, many privileged people are able to swindle the banks and then leave the country, go somewhere else, and escape the grip of the law. Okay, so would we say that in those situations there is no law at all? Okay, there is no legal obligation at all? Seems to be problematic, isn't it? So he has to give you an account of an explanation for how even in those cases when people escape the grip of the law, there is still a legal obligation and there still is a law. Okay, which is not possible if you subscribe to Austinian definition. It's because it's descriptive in nature. Okay, it does not talk in terms of that ought, okay, that normative ought that could possibly exist. Okay, now moralist would say the problem is because you say that law and morality are to be kept separate. So Hart has to tell you that no, there could be an ought, there could be a normative requirement here in terms of law, even when we say that laws and morality are to be kept separate. Okay, so let's see how he does it. Okay, so just remember Austin's positivism is descriptive, okay, and Hart's positivism is kind of prescriptive, but not in a moral sense of the term. And how does he do that? Let's look at an example that that is discussed quite often. So yeah, imagine that a robber, okay, approaches you, okay, okay, and then points a gun at your head, okay, and then says that, okay, give me the money that you have in your pocket, okay. So you would say that, okay, you are to decide whether you are to hand over the money or not, okay. So you would think about it, okay, how likely is it that I will get shot, and if I do not give the money? You come to the conclusion there is a very high likelihood that I'll be shot if I do not hand over the money. So you hand over the money. Well, did you have a legal obligation here to hand over the money? Okay, because there was a command by someone who's obviously superior to you, okay, has the power to enforce obligation here, enforce the kind of obligation that Austin would talk about here, okay. And there is a threat, okay, if you do not pay, then I'll shoot you. So there'll be sanctions which are imposed on you. So because of that, threat, that, force, okay, you hand over the money. So would we say that the robber here is the sovereign, and what the robber did, the command of the order of the sovereign to hand over the money is a case of law? Well, or would you say that the robber was breaking the law? Okay. Well, if you follow the Austinian definition, you probably have to say that, well, this is a case of law, and because there's a superior who commanded, that create a duty in me, and well, did it create a duty? But if you follow the Austinian definition, you cannot say no, okay, because where did the duty come from? Because there is a command from someone who's superior to you, and there was a threat of sanction, okay, because of that you handed over the money. So yeah, this seems to be a case of law, and it did create a legal obligation. But we wouldn't accept that, would we? We would say that, as we discussed earlier, that no, this is not a case of law. Then what is it that's lacking here? So as you know, so for example, here the sovereign was asking for money from you. Okay, sorry, the robber was asking for money from you. Sovereign, okay, also enacts law, okay, in a legal system, laws are enacted by the legislature that imposes tax on you, okay. So in that case, the state is saying that, yes, hand over to us your money, okay, as determined by the law, okay. And you know that if you do not pay taxes, you face consequences, okay. So yeah, it could be imprisoned as well, fined or whatever, okay. There are consequences, okay. Those are sanctions, as Austin would say, okay. Now, if you do not pay the tax here, then yeah, there will be consequences. And if you do, then yeah, you're following the law. Now, how would we distinguish between this situation where the state is saying that, okay, give us this money, or this is the fine, this is the punishment, from that of the case of that robber, okay, who points a gun at your head and then asks you to hand over the money? What's the distinction, the difference between these two situations? In one case, we say that it is not a case of law. In the other, we say that, yes, it is a case of law. Even when you think that, okay, the tax is probably excessive, or it ought not to have been there, you still think, okay, in the second case, that because there is a law, everyone ought to abide by it, okay. So there is a kind of acceptance of the law, even when you disagree with it, okay. So that's something which is lacking in the definition of law given by our previous philosopher John Austin, okay. It's not there, okay, which is not accounted for. That element of exception and acceptance of the law by the people upon whom it is, for whom it is created, okay. Whereas in case of the Robert, there is clearly not a case of acceptance. Okay, it's merely based on fear, the threat of sanction that he's like you are handing over your money. But in case of the state, it's not merely. Yeah, quite often, yeah, we do follow. There are many amongst us who do follow the law because of the threat of sanction, but not all of us. I mean, most of us do not obey the law because there is a threat of sanction. We also believe at the same time, okay, even when we do not like the content of the law, that we ought nonetheless to follow the law. Okay, that's the element which is not captured by the definition of law given by Austin. Okay, so when that approach of Austin is taken to extremes, okay, by some other thinkers who think just like the positivists but in a certain different way. So for example, legal realists, okay, they would say, okay, and some of them would say that rules, laws, and the rules, okay, which constitute laws, okay, they do not really exist, okay, they do not convey much, okay. So what is law then? Okay, they will think that what is law is what is decided in the court of law, how judges actually apply the law, and whether the law is actually applied. Okay, so and what is the content of the law then? How would we know whether the law exists or not? Some of the legal realists would say that, okay, you have to think in terms of whether you have a legal obligation or not. You have to think in terms of a bad man. Okay, it's the bad men would always test the limits of the law. Okay, so those limits are actually cases of law, and those limits are where legal obligation is created. So as a bad man, you will think about how likely is it that if I steal this thing, okay, that I will be caught. Okay, well, you will think about how likely that you are caught. How likely is it that judges will believe, okay, in the evidence? Okay, how likely is it that you will actually be punished, and how long you will serve? All those things will definitely be in the mind of the bad person who's testing the legal system. Okay, so if the bad person thinks that, okay, I will not do this because this is the consequence that will ensue, then you can say that in such situation you have a legal obligation. But that's not how it works. Okay, that's not how it works. So let's take another example. So which is discussed, as well. So for example, there are laws, okay, that say that. So when when you are on road, okay, you see traffic lights there. Okay, green says go, red says stop, orange says wait. Okay. So you have that, okay, and the law says that, okay, if the light is red, then go, and if the light is green, if the light is red, then stop. If the light is green, then go. Okay. Quite often you see that if there are no cars coming, okay, people, or even when there are cars, in our case, okay, people jump the light. Okay, jump the light. So even when it is red, people just do not obey it. Okay. So does that mean that, okay, because there are cases of infraction of what we call as law here, or called rules here, does that mean there are no laws? Okay. HLA Hart would say that no, just because there are people who are successfully able to escape the grip of the law does not mean that there are no laws in those situations, or that there are no legal obligations in those situations. Law exists, legal obligation exists. Okay, this is essentially what he would talk about. Okay, now this validity of the law that he's talking about, okay, whether the law exists, whether the law is valid or not, okay, is not something, okay, despite the ought that he's talking about, despite the normativity that he's talking about, okay, is still to be kept separate from question of morality of law, whether the law is morally binding or not. So this normativity of law is separate from moral bindingness. Okay, so legal obligation is separate from moral obligation. Okay, so whether you have legal obligation or not, you will observe from the basic practice of a particular legal system. Yes, so that's essentially how he, how his approach to law is different from that of the one that is, developed by John Austin. So essentially, where there is a law, okay, as he would say, when there is a law, okay, human conduct is made in some sense non-optional or obligatory. Okay. So the idea of obligation is at the core of the idea of rule that he is talking about. So if you remember the example that I was talking about, okay, so you should understand it like this, okay. So when the gunman points a gun at your head and asks you to hand over the money, okay, you were obligated, okay, you were obligated to hand over the money, okay. You just didn't have the option, you just didn't feel that you ought to hand over the money, but you just did because of the fear of sanction, okay, as you will be shot. Whereas when there is a state-made law, okay, as he says, that makes your conduct in some sense non-optional or obligatory, that you ought to pay taxes, okay. Even in this case, yes, you do not have a choice, tax is imposed. Now you do not have the choice whether you pay the tax or not, okay. So an obligation is created, but in such case we would say that you have an obligation under the law to pay taxes, okay. You are not obligated, so it's not pure case of threat of sanction, which is the center of the idea of law. Yes, sanction would nonetheless be important, we are not denying that, but then the acceptance, the reflective acceptance of it within the society is also very important, okay. So yeah, that's the difference. I hope you guys understood, okay. So you are not obligated in the case of law, you are not obligated, but you would say that you have an obligation, okay. You may nonetheless say that, okay, it seems to be not proper, okay, but you would say that I have an obligation under the law to fulfill its requirement, to abide by the duty that it creates, okay. So yes, the idea of obligation is very essential here. It is the core of the core of rule, okay. If there is a rule, it creates obligation, okay. However, it's not of the same kind as you have clearly understood from from the case of robbers, okay, the case of robber demanding money from you. So there's this distinction that I hope understand between Hart's position and Austin's command theory. So the idea of command will explain a coercive order, okay, addressed to another in special circumstances, but not why statutes apply generally and also applies to its framers, okay. So this is a very important thing that you need to remember, okay. So in the first situation that we looked at, someone pointing a gun at your head, okay, it's something that is very specifically directed towards you, okay. So you can probably take up Austin's definition to only explain certain coercive order like this, okay. So in all cases of law, it seems to be some gunman pointing a gun at your head and asking for you to hand over your money, okay. But that's not how law actually works, okay. Statutes apply generally to all, okay, and it also applies as much, okay, equally to even its framers. So when a law is legislated, for example, the parliament, okay, even those who legislate the law is binding on them. So that's not accounted for by Austin's command theory, okay, which is accounted for by our philosopher here, HLA Hart. So I hope this is clear, okay. Now we'll discuss this in much more detail in later classes. Some other important aspects of HLA Hart's theory, which are development over that of Austin, are like this, okay. That in Austin's idea of law, which essentially consists of primary rules and secondary rules. So there are two different kinds of rules, okay. We will discuss them in greater detail. Primary rules creates rights and duties, okay. Secondary rules are of the nature of powers, okay. So these powers, okay, laws that create power. So for example, you can, so when the law says that you can create will, it does not say that this is the will exactly that you have to create. You now have the power to create a will. The law says that you have the power to dispose of the property. It does not say that you have to dispose of the property in a certain way, but it gives you the choice. It gives you the power to dispose of the property in a certain way, okay. Now these powers cannot be accounted for. These cases of laws, okay, creating powers we only have to stretch. We have to stretch the definition of command as given by Austin to account for the cases of laws creating power, which is accounted for in the definition of law given by HLA Hart. Okay. Further, the command theory it cannot adequately explain the cases of pre-existing laws which already exist. Okay, they do not, as you have seen from the discussions we had. Okay, they have to stretch the idea of command to a great extent to say that okay, there are laws. As you know, from when the regime changes happen, when one party loses, another party comes to power, so your legislators change as well. Okay, so while the transition happens, would we say that there are no laws because there's no one commanding during this transition period? And quite often you see that the earlier laws, okay, even when this transition is going on, still exists. Okay, so how would Austin explain the pre-existing laws, which he fails? Okay, that is accounted for in the in the theory of law given by HLA Hart. Okay, so and then Austin says that talks about the habit of obedience. Okay, and it's so habit of obedience. Okay, so that is very problematic. Okay, so the bulk has to habitually pay obedience to the political superior. Okay, determinate human superior. Okay, now when do we know that there is a habit of obedience? Okay, so, for example, one sovereign, in case of succession of sovereigns, so one sovereign loses power, another gains it, okay? When exactly can we say that there is law? So, Austin would say that when the bulk of the society pays habitual obedience. So, would we say that until that really happens, until we have that empirical, detail to say that there is a law, we see that in this intermittent period, we didn't have any law. So this is another problem which cannot be explained if you take up Austinian approach to law. Okay, so and on top of that, okay, quite often you will see that, as HLA Hart has pointed out, there are laws that determine how succession of sovereign happens. So in England, who gets to sit on the throne is determined by some kind of law, some laws of succession there. What about us? Even in our case, you see how there are election laws. Okay, those laws determine who get to be in power and who gets to make laws, who get to issue orders. Okay, so if law is the command of the sovereign, so how do we explain for these laws which then control the so-called sovereign? Okay, so succession to sovereignty occurs by virtue of acceptance of a rule entitling the successor to succeed. Okay, and where does that law come from? Well, how do we explain that? Well, Austin will not be able to explain that. Let's see how well our philosopher HLA Hart is able to explain that. So I hope this is clear to you guys. So this is a long lecture so far. So I think we could stop for today, and in the next class we will discuss about rules and the internal aspect of law, which we discussed to in a great extent today, but we will discuss it in a little more detail in the next class. So yes, I think HLA Hart will be completed in couple 2 more lectures, and then we will have some retorts, some replies given to his idea of separability of law and morality while on Fuller, and then the question of whether judges make the law or they merely apply the law. Those are the 2 questions that will be discussed, and we would have completed this. And after that, if we still have time, I hope we do, we will take up the other schools as much as possible. So thank you. Good day.